issue of master of roster has raised many controversies in the past as well. It goes to the heart of how the top court of the country is managed on the administrative side and which court or which bench hears what matter. We remember, sir, the infamous press conference of the four judges of the Supreme Court. Your thoughts on this matter, and more importantly, has this issue really resolved? Have we found more transparency and accountability?
So, when this press conference happened of these four judges of the Supreme Court, Justice Kurian, Justice Chelameswar, Justice Madan Lokur, and Justice Gogoi, unfortunately or fortunately, I was the president then of the bar. And I remember when this press conference was happening, I was in Orissa arguing a matter, and the moment I landed here, all the media people started, hounding me as to what is my comment on this. We immediately called an executive committee meeting. We deliberated on this and we passed a resolution. And one of the important resolution was that there should be a roster in Supreme Court. Most of the high courts have a roster. And when you say roster, I mean that there should be categories of cases which should go to a particular judge or to a number of benches. So there could be criminal rosters, there could be income tax rosters, there could be tax rosters generally, or there could be family law, transfer petitions. Now each bench did not decide only one particular issue. There could be 5, 6 things, because there are so many types of cases coming in Supreme Court. Each bench will definitely have 5, 6 or 7 issues to be taken up. The other part of our recommendation was that once you have a roster, then the matter of that roster or which had to go to a particular judge by virtue of that roster should be randomly selected. So if supposing 12,001 SLP is the first matter in a criminal matter in a particular month, and the second SLP is of criminal is 12,005, then 12,001, then 12,005, and then 12,009, whichever is the next criminal matter, should go by rotation to the various benches which are hearing the roster. So the Chief Justice of India, according to me, should have the primacy of deciding the roster itself. And according to me, that also he should ideally consult the Collegium of Judges, because he should try and find out which judge is good in what particular subject and try to assign matters according to the expertise of the particular judge or the judges in the Supreme Court. It's a different matter, although, that in Supreme Court, judges end up doing issues which they had never done in their lives, and they learn and do, and that's something which is very salutary, and we must compliment the judges, because in the high courts you normally have done a very limited number of cases and limited number of issues, and here you are made to do all kinds of issues. So that roster is to be decided. The roster, within the roster, it has to go by random basis, rather than Chief Justice of India saying that 12,001 should go to this roster and 12,005 should go to that roster. No, that's not the job of the Chief Justice of India. When you say master of the roster, that master of the roster becomes important when a judge recuses to hear a matter, for either he knows the party or for whatever reason he has some interest in that matter. So when that matter goes to the Chief Justice, ideally if it's a criminal matter, then that also should go to the next bench, which is handling criminal matters. And really speaking, that also doesn't call for consideration for a constitution of a special bench for deciding when a judge recuses. There are instances where a matter has been decided by 2 judges or 3 judges and one of them retires and a new bench is to be constituted. That definitely will be done by the Chief Justice of India as master of the roster. He will decide which bench should hear this matter in the absence of 1 judge or 2 judges who have retired. So the functionality of the Chief Justice of India, as far as being the master of the roster, is a limited functionality. Firstly, to decide the roster itself, that which bench should hear what matter, and once that is decided, then matters to go as per randomly in that roster. And secondly, if there is a matter which requires a special bench to be formed, then that should be decided by the Chief Justice of India. So I think the master of the roster principle has been more misused in recent times. I'm quite glad that Justice Gawai followed this principle largely, and I'm sure Justice Suryakant will also continue to follow. But before that, the Chief Justice of India, then Chief Justice of India, before Justice Gawai, definitely was not following this roster. He used to pick up matters from one particular bench and assign it to some other bench, which is definitely not the role of the master of the roster. Interestingly, there is a Supreme Court rule which also prescribes that once a judge issues notice in the matter, then it should remain with that judge only when it comes up later. Unfortunately, even that is being breached in many cases, and we see that notice is issued by one judge and the Chief Justice of India intervenes and posts that same matter before some other judge. That is also not the usual practice in the Supreme Court, and I think that also is a aberration of the power of the master of the roster as far as listing of matters is concerned.